Good morning, everyone. We are here to once again do a little short video on a case that recently was decided by the United States District Court for the District of Colorado, Judge Nina Y. Wong. Civil action number 22CV01129, Eric Coomer versus Michael J. Lindell, Frank Speech LLC, and My Pillow Inc. This is titled An Order to Show Cause. This case is, I'm not sure what the underlying case is about, but there's a dispute. The plaintiff is getting the case ready for trial. The defendants, both sides, had obligations to get their pretrial materials into the court. Apparently those deadlines were set in October of 2024, and the court said, we're going to hold a conference, and we're going to, in 2025, and we're going to discuss the motions in limine. What are motions in limine? Those are motions to exclude evidence. So you file them before the trial. You let's say there's some evidence about your client that you don't think should come into the record or be heard by the jury. You'll file a motion saying it's irrelevant, it's improper. You'll argue whatever reasoning you have to eliminate that evidence. They're commonly used before trial. Most trials will have at least 10 of them, sometimes more. The problem here is the brief filed by Mr. Lindell and his lawyers, and the problem came up at the pretrial conference. And I'm gonna quote here from the second page of the opinion. Quote, as discussed extensively on the record, after confirming with Mr. Kachuroff, that's defendant's counsel, that he signed the opposition consistent with his obligations under Rule 11 of the Federal Rules of Civil Procedure. The court identified nearly 30 defective citations in the opposition. These defects include, but are not limited to, misquotes of cited cases, misrepresentations of principles of law associated with cited cases, including discussions of legal principles that simply do not appear within such decisions, misstatements regarding whether case law originated from a binding authority, such as the United States Court of Appeals for the 10th Circuit, misattributions of case law to this district, and most egregiously, citation of cases that do not exist. Quote, despite having every opportunity to do so, Mr. Kachuroff declined to explain to the court how the opposition became replete with such fundamental errors. For example, when confronted with the first misquotation in a parenthetical appearing on page 3 of the opposition, purportedly drawn from Matta v. City of Farmington, 798 F sub 2nd, 1215, Mr. Kachuroff stated to the court, Your Honor, I may have made a mistake and I may have paraphrased and put quotes by mistake. I wasn't intending to mislead the court. I don't think the quote is far off from what you read to me. And then the court went on and had further discussions. When asked whether he would be surprised to find out that the citation Perkins versus Federal Fruit and Produce Company, 945 F 3rd 1242, 1251, 10th Circuit 2019, appearing on page 6 of defendant's opposition, did not exist as an actual case, Mr. Kachuroff indicated that he would be surprised. Time and again, when Mr. Kachuroff was asked for an explanation of why citations to legal authorities were inaccurate, he declined to offer any explanation or suggested that it was a draft pleading. Quote, not until this court asked Mr. Kachuroff directly whether the opposition was the product of generative artificial intelligence did Mr. Kachuroff admit that he did in fact use generative artificial intelligence. After further questioning, Mr. Kachuroff admitted that he failed to check the authority in the opposition after such use before filing with the court, despite understanding his obligations under Rule 11 of the Federal Rules of Civil Procedure. Quote, even then, Mr. Kachuroff represented that he personally outlined and wrote a draft of the brief before utilizing generative artificial intelligence Given the pervasiveness of the errors in the legal authority provided to it, the court treats this representation with skepticism. So, under Rule 11, every pleading filed in federal court, someone has to sign that pleading, verify that it's true, that the statements of fact within it are true, and that it has a sound basis in the law, or an argument to expand existing law. The problem you have here, obviously, is that artificial intelligence was used. There is no basis for these citations because they don't exist. It is well known now that AI makes up citations. It will simply take what you have provided and expand on that. And it's like in some ways it has a very human characteristic. Its desire is to, I don't know if we can say it has a desire, but it tries to give you what you want. And so what you end up with, if you want a case that says something that isn't true, it will provide that to you. The end result is, this has happened many times, the end result is that there's going to be a show cause hearing, and then there's going to be also discipline. The court is going to refer them to the discipline authorities of the states where they're licensed. So let's read the end. Quote, given the record before the court on the wholly deficient preparation and filing of defendants' opposition to plaintiff's motion in limine, it is ordered that 1. On or before May 5th, 2025, defendants' counsel shall show cause in writing why this court should not sanction defendants Michael Lindell, Frank Speech LLC, and My Pillow Inc., the law firm of McSweeney, Sinkar, and Kachuroff PLLC, and the individual counsel, Christopher I. Kachuroff and Jennifer T. DeMaster, who signed the opposition to plaintiff's motion in limine. And then it goes on or before May 5, 2025, defense counsel shall show cause in writing where this court should not refer the lawyers to disciplinary proceedings for violations of the applicable rules of professional conduct. And then paragraph 3, counsel will specifically address under oath, subject to the penalty of perjury, the circumstances surrounding the preparation of the opposition to plaintiff's motion in limine, including but not limited to whether defendants were advised and approved of their counsel's use of generative artificial intelligence. 4. No later than May 5, 2025, defense counsel of record shall certify that a copy of this order has been provided to defendant Michael Lindell personally. So so despite the risks of engaging in this type of behavior, and there have been other cases where this has happened, lawyers continue to ask AI programs to do their work for them. And the AI program, when it can't find real citations that support what the lawyer wants it to say, it makes up cases. And despite multiple warnings, news stories, and other efforts to tell lawyers about this, CLE courses, lawyers continue to make these mistakes over and over again. This is just something to be aware of. I guess you can use AI in your practice, but you shouldn't use it to draft a brief unless you personally check the sites yourself. Personally check it. You can't file things that aren't true, and it's going to get spotted right away because the other side's going to go look for those cases. They're going to crack they're not going to crack the book anymore, but they're going to go and look online, and they're going to find that the case doesn't exist, and then they're going to tell the court, and the court's going to start looking, or the law clerk for the judge is going to find this one may have been found by the law clerks. The plaintiff's lawyers seem they're not discussed in here in this opinion, but the price, far better just not to oppose the motion in limine, lose, than to file a false brief, a fake brief. So this is just something to be reminded of, that the price of this type of behavior far outweighs the potential downsides. Despite that, people seem to do it again and again, and to make themselves targets for this type of abuse. You just simply can't do this. That's the bottom line. Thank you.